Hello everyone. In this video, we will discuss case laws related MCQs of Constitution of India. I have already made part 1 of this series. Here we will discuss MCQs of fundamental rights. So let's get started. First question. The object of the framers of the Constitution of India to establish what is generally known as the welfare or the social state has been held in. Option A. Motilal versus Uttar Pradesh government. Option B. Dorai Rajan versus State of Madras. Option C. K. Gopalan versus State of Madras. Option D. None of the above. The correct answer is option A. Motilal versus Uttar Pradesh government. Question number 2. The Supreme Court in State Trading Corporation of India versus Commercial Tax Officer 1963 observed that a company registered under the Companies Act 1956 is dash. A. Is a legal person but it cannot avail itself of fundamental rights under the Constitution available to citizen only. Option B. Can neither claim legal personality nor right of a citizen. Option C. Is like a citizen of India and can avail itself of all rights available to its citizen of India. Option D. Is a legal person and equivalent to a group of citizens. The correct answer to this question is option A. Is a legal person but cannot avail itself of fundamental rights under the Constitution available to citizens only. Coming to question number 3. That fundamental rights guaranteed in Part 3 of the Constitution of India cannot be waived by a citizen was held by Supreme Court in one of the following cases. Options A. Basveshwar Nath versus CIT. Option B. Bikhaji Narayan Dakras versus State of MP. Option C. State of Bombay versus FN Balsara. Option D. State of Gujarat versus Sri Ambika Mills. The correct answer to this question is option A. Basveshwar Nath versus CIT. Question number 4. Match list 1 with list 2 and give the correct answers by using the quotes given below the list. Option A. Article 329 is Indira Nehru Gandhi versus Raj Narayan. Option B. 10th Schedule Part 7 Quixote versus Zakilu. Option C. Article 31C is Keshwananda Bharati versus State of Kerala. And option D. 13 Clause 2 is Golaknath versus State of Punjab. Coming to the next question, it's concept of state. First question in this. The 7-judge bench of a Supreme Court of India in Pradeep Kumar Biswas versus Indian Institute of Chemical Zoology 2002 overruled its judgments in the case of option A. Sabhajit Tiwari, option B. R.D. Shetty, option C. Ajay Hasya, option D. G. Basireddy. So the correct answer is option A. Sabhajit Tiwari. Question number 2. In which case, for the first time, the Supreme Court had laid down certain principles to decide as to when a corporation can be said to be an instrumentality of state. Option A. R.D. Shetty, that is Ramana Dayaram Shetty versus International Airport Authority of India. Option B. Sukhdev Singh versus Bhagat Ram. Option C. Rajasthan State Electricity Board versus Mohan Lal. Option D. Som Prakash Rekhi versus Union of India. The correct answer is option A. Ramana Dayaram Shetty versus International Airport Authority of India. Next question. In which of the following case the Supreme Court held that if a body is an agency or instrumentality of government, it may be an authority under Article 12. It was held in option A. Ujambai versus State of Uttar Pradesh. Option B. Ramana Dayaram Shetty versus the International Airport Authority of India. Option C. Electricity Board Rajasthan versus Mohan Lal. Option D. P.D. Shyamadasaru versus Central Bank of India. Correct answer is option C. Electricity Board Rajasthan versus Mohan Lal. Question number 5. Board of Control for Cricket in India, BCCI, is not financially, functionally or administratively dominated by government, nor it is under control of government, therefore not a state. Was held by the Supreme Court of India in option A, Z Telefilms versus Union of India, option B, Star Plus Limited versus Union of India, option C, Kolkata TV versus West Bengal, option D, above statement is false. But the correct answer here is option A, Z Telefilms versus Union of India 2005. Question number 6. Match list 1 with list 2 and select the correct answer using the codes given below. List 1. Damages in public law is Neela Bhati Behra. Death penalty Bachchan Singh. Option C. Prospective overruling Golaknath. Option D. State under Article 12 of Constitution is Pradeep Biswas. Next question related to Article 13 of the Fundamental Rights of Constitution. Question number 1. Judicial review of the 9th schedule of the Constitution has been made permissible by which of the following cases decided by the Supreme Court? Option A. Keshwananda Bharti versus State of Kerala. Option B. M. Nagaraj versus Union of India. Option C. Minerva Mills Limited versus Union of India. Option D. I.R. Koilo versus State of Tamil Nadu. Correct answer is option D. I.R. Koilo versus State of Tamil Nadu. Question number 2. Clause 4 of Article 13 of the Indian Constitution, which was inserted by the 24th Amendment Act 1971, states that a Constitution Amendment Act passed according to Article 368 of the Indian Constitution is a law within the meaning of Article 13 and would accordingly be void if it contravenes a fundamental right. This amendment was declared void in which of the following cases? Options are A. Golaknath versus State of Punjab, B. Edward Mills Company Limited versus State of Ajmer, C. Minerva Mills versus Union of India, D. Ghulam Sarwar versus Union of India. The correct answer is option C. Minerva Mills versus Union of India. The Supreme Court of India formulated the doctrine of eclipse in option Bikaji Narayan versus State of Madhya Pradesh, option B Baseshwar Nath versus Income Tax Commissioner, option C State of West Bengal versus Anwar Ali Sarkar, option D Maneka Gandhi versus Union of India. The correct answer is option A Bikaji Narayan versus State of Madhya Pradesh. Question number 4. The doctrine of prospective overruling established in the case of I.C. Golaknath versus State of Punjab 1967 can be applied option A by any court of the country, option B by any administrative tribunal of the country, option C only by the highest court of the country, option D only by the revenue authorities under the Land Ceilings Act. The correct answer is option C only by the highest court of the country. Question number 5. Which one of the following cases is not related to the doctrine of severability? Option A. A.K. Gopalan versus State of Madras. Option B. RMDC versus Union of India. Option C. Minerva Mills Limited versus Union of India. Option D. Quixota Holland versus Zakilu. Option C is the correct answer, that is Minerva Mills Limited versus Union of India. The term law includes every branch of law, yet there is difference between constitutional law made in exercise of sovereign powers and hence an amendment is not covered within the definition of the law provided under Article 13 Clause 2 and 13 Clause 3 of the Constitution of India. This observation was made by the Supreme Court in option A. Sajjan Singh versus State of Rajasthan, option B. Shankari Prasad versus Union of India, option C. Golaknath versus State of Punjab, and option D. Maneka Gandhi versus Union of India. The correct answer to this question is option B. Shankari Prasad versus Union of India. Question number 7. The right of a person to be appointed as guardian of his minor children under the personal law is not a fundamental right, was decided by the Supreme Court in one of the following cases. A. Muhammad Aslam vs. Union of India. B. Shifazada Saeed Muhammad Amir Abbas Abbasi vs. State of Madhya Bharat. Option C. Khatri vs. State of Bihar. Option D. Muhammad Farooq vs. State of MP. The correct answer is option B. Shifzada Saeed Muhammad Amir Abbas Abbasi vs. State of Madhya Bharat. Next question. Which of the following cases are related to doctrine of eclipse? Option A. Deep Chand vs. State of UP. Option B. State of Gujarat vs. Ambika Mills. Option C. Dulair Lodh vs. 3rd Additional District Judge. Option D. All of the above. The correct answer is all of the above. Next question. Match list 1 with the list 2 and select the correct answer using the codes given below. Doctrine of waiver is Basesha Nath vs. CIT. Option B. Doctrine of eclipse is Bikaji vs. State of MP. Option C. Doctrine of severability is option 4, that is State of Bombay vs. FN Balsara. And option D. Doctrine of repugnancy is Kaisar-e-Hind Private Limited vs. NTC. Question number 11. Match list 1 with list 2 and select the correct answers using the codes given below. Doctrine of eclipse is Bikaji vs. State of MP. Doctrine of severability, RM Desi vs. Union of India. Doctrine of waiver is Basesha Nath vs. Income Tax Commissioner. And doctrine of pith and substance is State of Bombay vs. FN Balsara. That is option 2. State doctrine of pith and substance is State of Bombay vs. FN Balsara. Question number 12. The leading case on doctrine of eclipse is option A. RMDC vs. Union of India. Option B. Jagannath Prasad vs. UP. Option C. Bikaji vs. MP. Option D. Kameshwar Prasad vs. Bihar. The correct answer is option C. Bikaji vs. MP. Question number 13. In which of the following cases it was held that the doctrine of eclipse is applicable not only to the pre-constitutional law but also to the post-constitutional laws? Option A. R.C. Cooper vs. Union of India. Option B. State of Gujarat vs. Sri Ambika Mills. Option C. Maneka Gandhi vs. Union of India. Option D. K. M. Menon vs. State of Bombay. The correct answer is option B. State of Gujarat vs. Sri Ambika Mills. Question number 14. In the view of the Supreme Court's decision in popularly known as Sabarimala case, the expression all laws in force in Article 13(1) of the Constitution of India includes option A. Law passed by or made by a legislature or other competent authority in the territory of India immediately before the commencement of the Constitution and not previously repealed. Option B. Customs and usages and personal laws. Option C. Both of the above. And option D. None of the above. The correct answer is option C. Both of the above. That is option A and option B. Question number 15. The judgment of Supreme Court of India in the matter of Minerva Mills Limited vs. Union of India, reported as 1980, pertains to option A. Constitutionality of the provisions of Constitution 25th Amendment Act. Option B. Constitutionality of the provisions of Constitution 39th Amendment Act. Option C. Constitutionality of the provisions of Constitution 42nd Amendment Act. And option D. Constitutionality of the provisions of Constitution 44th Amendment Act. The correct answer is option C. Constitutionality of the provisions of Constitution 42nd Amendment Act. That's all for today's video. In the next video, we shall see the Fundamental Rights Article 14 and further articles. Thank you.